We're here on the defendant's motion for attorney fees. Mr. Haslam, I have read the motion. Is there anything else you'd like to say at this time?
I do have a few things. I do have a few things to add, Your Honor, that I think are germane to this motion. Number one, when we take the plaintiff's own appraisal and subtract the latest, at least the latest figure we have been provided with, I think from April, with respect to the marital home that she claims is all hers and refuses to acknowledge that there was any marital equity built up over the marriage, purchased with about a $17,400 down payment 2.5 weeks before marriage. That's a $340,000 source of untapped equity. She also has, again, according to the figures we were provided that date from March, over $172,124 in a 403B contributory retirement plan, which gives her, not with exactitude, because we're not subtracting her, credit card debt and things like that, I suppose, but that isn't that large. We've got a plaintiff here with a net worth exceeding $500,000. When we look at the other side, the flip side of this coin, this was a case and is a case, Your Honor, essentially of, I would suggest, gender reversal. We have a husband who doesn't earn very much. He has almost $382,000 in student loan debt, and he had to purchase a replacement transportation, that Toyota. And so that is very heavily leveraged. From the time of being in medical school, pursuant to the agreement of the family, his credit cards are tapped out. He does not have the ability, Your Honor, to walk into a bank and say, give me a personal loan. I think, as this court knows, anybody can go buy a car. That's because the new car is the collateral for the loan. And if you don't make the payment on the loan, they repossess the car and sell it. He's borrowed in the interim $10,000 from his mother, who I believe is in her 80s, but he has tapped out here his ability to borrow. And I know that counsel has thrown around a number of speculative and unsupported assertions in their response by plaintiff to this motion. They say he doesn't pay for anything. Anything he earns is just free mad money. Absolutely not true. He pays for the family's health insurance. He pays for auto insurance. He buys groceries. He pays all of the expenses for the children's expensive travel soccer, including the registration, uniforms, equipment, pays for the tournaments, and pays for the travel to take them on these travel soccer expeditions. And I know from personal experience, having done that with 2 of my children, it is very expensive. They say his loans are going to be forgiven. Absolutely not true and absolutely speculative. I think this court knows the status of student loan forgiveness programs. My client is not involved in a student loan forgiveness programs. The only way these loans are going to be paid back is by him paying them. And that's the fact at this point. That's entirely speculative. They say he should go borrow against his 403B. He isn't vested sufficiently to the point where he can borrow against the nominal amount of money in there. If I recall correctly, I think that's somewhere in the range of about $30,000, but he simply can't tap that at this point. The plaintiff also makes some misleading assertions and doesn't include dates in terms of this alleged loan the plaintiff took against her 403B some years ago. Both of these parties apparently had some credit card debt they wanted to pay off. And since my client was still a medical student at the time, she borrowed some money against her 403B and they paid off those credit cards. But that was years ago. And his credit cards are back to being maxed out because of all the expenses that he has incurred. And I would be remiss if I didn't tell the court that part of the process with respect to his attending medical school was that he didn't just borrow, Your Honor, the money to pay the tuition and fees and direct costs. He took additional I think they're called plus loans, to recontribute what his income would
Let
have
me let
been.
me stop you a moment, Mr. Haslam. I read all
Mhm.
that, so we're just kind of rehashing what I already read. So,
Well, Your Honor, I wanted to respond to some of the misrepresentations made by the plaintiff here. And I know there's a question, and I think plaintiff raises it rhetorically. Well, he was only asking for 15,000 before, now he's asking for more. Well, as you read in my supplement, Your Honor, we wasted almost an entire day at mediation with no response other than just flat no's to the plaintiff. We then find out that they have hired a very expensive valuation analyst, Michelle Gallagher, and paid $5,000. She claims the source of some of her expenditures are loans from her parents. We've seen no promissory notes. To the extent her litigation is being funded, when she makes between $150,000 and $160,000 a year being funded by third parties, I think that makes it more appropriate to give him an award of fees. Look, she's taken the position that as far as their children are concerned, and they're both still living together in the marital home, he can have parenting time as they agree when he's not working, and that should be in a final judgment. And that none of this $340,000 in equity in the marital residence he's entitled to. And then they have the temerity to file a response to a motion alleging in a public court file, implying that somehow my client, when getting massages to treat his spinal radiculopathy, his cervical spine radiculopathy from his years of firefighting, that somehow he's consorting with prostitutes. I find that argument and that strategy to be absolutely, simply absolutely inappropriate. We're asking for the increased amount because unfortunately we can see the handwriting on the wall here. And with her $500,000 in assets to fund this, in addition to receiving additional money from her parents, my client being tapped out and his only source of funds being his 80-something-year-old mother, and that has come to an end. He is entitled to an award of fees and costs under MCR 3.602D to enable himself to hire an expert, pay his lawyer, and fund his defense of this action.
Mr. Burke.
Thank you, Your Honor. I don't want to regurgitate what is in my responses and briefs. I know that was probably a lot of reading for you, but I want to just note the timeline of defendant demanding $25,000 in attorney fees. He filed this motion immediately before mediation in an attempt to coerce a settlement. And Your Honor, Ms. Brandt did participate in mediation in good faith. We actually went over the time limit that we had originally scheduled for mediation. I pushed back appointments in that day to complete mediation. And quite simply, we weren't going to agree to defendant's demands. And what does he do after this? He increases it by $10,000 after mediation. And quite simply, this is nothing more than a money grab, Your Honor. The defendant makes $65,000. As referenced in my brief, that is an average household income in Michigan. And the only financial document before this court, when it's defendant's burden to prove this motion, is actually an exhibit that we submitted showing his attested monthly expenses, which are nominal. I've recently reviewed some financial statements provided by defendant showing that his student loan payments are about $50 a month from the withdrawals that I could see out of one account. I know that Mr. Haslam focused on the equity in the house. That's not relevant as to an ability to pay. And the reality is that Ms. Brandt still has a loan against her retirement account for the $14,000 credit card fees that she paid on defendant's behalf. I do want to just reference briefly excuse me here, Your Honor, the Smith v. Smith case that is referenced in our brief in support. Mr. Haslam is familiar with that case, and it comes from this circuit court and then affirmed on it by the Court of Appeals, showing that it is defendant's burden, not through blanket assertions in an affidavit, but providing actual financial documents to support the requested relief. The defendant has very minimum expenses, and his income is quite simply disposable income that he uses for his sole benefit. We ask that the court deny this motion. We think that he has the ability to pay, especially considering the fact that in less than a year, he's going to be making in excess of over $300,000. In addition to that, there are several loans available for resident physicians, recognizing that in this interim residency period, they don't make significant money compared to what they will make outside of their residency. He has funds available to him, and we ask that the court deny this motion.
All right.
Thank you, Your Honor. As the court no doubt is well aware, I am familiar with Smith versus Smith. It's my reported case in the Michigan Court of Appeals dealing with termination or modification of post-judgment spousal support based on cohabitation. That's a completely different context, and it really is inapposite to a request for attorney fees and costs to enable my client to defend this action. He doesn't have $5,000 to hire somebody like Michelle Gallagher in this situation. He's entitled to do that, and he's entitled not to be oppressed by the party with all the assets and all the money. Like I said, you take a look at that net worth, my client's a negative almost $400,000, and the equity in the home is certainly relevant. One can set up a home equity line of credit in about 48 hours to have access to those funds. And for counsel to sit here and say, I know about loans that are maybe available to resident physicians. Again, speculation, just like, oh, all his student loans are going to be forgiven, with absolutely no factual support. What we do have factual support for, Your Honor, is that the plaintiff here has an income that far surpasses my client. And we have to look at this point in time. Number two, he's tapped out his available lines of credit. Number three, the plaintiff will continue in this litigation. She has engaged this expert. She says she's going to value his degree. We have to be able to do that as well. And we can't be victimized by the plaintiff's obvious plan here to put Ryan in a position where he can't pay his lawyers. His outstanding bill with me, I think, is almost $9,200 at this point, and to hire an expert. Now, when I asked for the itemized billings that the plaintiff had paid her lawyer, they claimed it was privileged and only sent me transfer documents showing money being transferred from their trust account, I believe, to their general account. But in any event, look, we have a huge disparity in income. We have a humongous disparity in assets. Will he likely make some money in the future? Probably, but we have to get through this case now. Our 1-year anniversary is coming up, I believe, in February, and he has to have funds available to him at this point to defend this action. We don't care if the court labels this temporary attorney fees or labels it an advance that would be determined later by the court as to whether it's attorney fees or an advance on his property settlement award. Either one. But right now, he does not have the money to adequately defend himself in this action.
All right, thank you. Pursuant to MCR 3.206, based on the information that the court has at this point, the court finds that the plaintiff does have the ability to assist in attorney fees for the defendant, that the defendant does have some need, given the disparity of income and the litigious nature of this case, particularly with the hiring of an expert. So the court will grant $15,000 as an advance on any ultimate property settlement.
How soon is that to be tendered to my trust account, Your Honor?
14 days.
14 days. Thank you. I'll prepare an order.
All right. Thank you.